Welcome, everyone. I'm Tony Ross, president of the Beverly Hills Bar Association. I'd like to welcome you to the 2021 Ethics Year in Review. First, let me remind you about the Beverly Hills Bar Foundation, which is a 501c3 public charity that supports BHBA's programs that promote equal access to justice, community service, and law-related education. Please donate to the Scholarship Fund, and the link is in your chat. We're very pleased to welcome two legal ethics expert panelists for today's exciting program. We have Carole J. Buckner of Procopio, Cory, Hargreaves, and Savitch, and Rachelle H. Cohen of Kehr, Schiff, Klein, and Cohen, LLP. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA's members-only community. Please take a moment to complete the survey that is included with your certificate. And now on to the program.
Thank you, Tony, for that introduction. I'm going to share my screen so we can share the slides that are in your material. And we will begin with Carole starting off, and I'm really glad to be here with Carole today.
Hello, everybody. First of all, let me just tell you a minute about my background, Carole Buckner. I am an ethics lawyer, as Tony indicated, as Rachelle also is. And Rachelle and I are also both members of the California Lawyers Ethics Committee. We spend a lot of our time devoted to legal ethics and professional responsibility and risk management, and we're very happy to be with you here today. What we tried to do is put together an update of some of the most important, most significant topics for lawyers to be reminded of. And we look back at cases, ethics opinions, and discipline decisions over the past year, and are going to bring you some of our highlights from that. So let's go to our first case. The first case I'm going to talk about is Fourth Dimension Software, which is on your slide. This case involves waiver of attorney-client privilege. And this is a very important topic for all attorneys to be reminded of. Obviously, in this case, the issue was whether discovery would be compelled for an email that was sent from a former general counsel to a CEO. And then the CEO forwarded the email to the hotel front desk to their generic email account, and he requested that a copy of the email be printed. He did not say anything about this is highly confidential or keep it privileged or be careful with it or anything like that. And so the question the case addressed when the other side was seeking discovery of this particular email was, is this a privileged communication to start off with? And the court said, yes. It's interestingly, even though it was a former general counsel, he was giving legal advice to the CEO. And so it was a confidential communication between a client and their counsel, which is typically going to be what is required for the privilege. But then the court had to decide, was the privilege waived? And this, I think, is the important part of the case. And maybe you picked up on this right away. The court in this case said this was a waiver because it was not necessary to the representation to share this information. And that is the test under the evidence code. Is it necessary to accomplish the purpose of the representation to share this information? The court said no, and this was a waiver. So very important to think about this and for your clients to be aware of it as well as we're dealing with confidential and privileged communications. So let's turn to Rachelle. She's going to talk a little bit about work product.
Yeah, so moving to the work product privilege and the Curtis case that I have cited here. So let me tell you a little bit about the facts of this case. So Curtis is a lawyer who has a client, Roma Santa. Roma Santa or his business gets sued by an employee, but Curtis is not an employment lawyer. And so Roma Santa hires a trial lawyer to handle the employment case. But Curtis, it's a long-term client. He stays involved in the case. And since he's not an employment lawyer, he looks to a consultant to give him information about employment laws, about strategies, and to help Curtis with his contributions to the case. So the case goes on. After the case is over, there's an attorney's fees hearing. And at that time, the plaintiff's lawyer in the employment case goes to a listserv. This is the California Employment Lawyers Association listserv. Any of you who do employment law might know about this listserv. And posts on that listserv his strategy about the case, how he won, and gives details. Well, somebody, in this case, there's a reference to a Doe 1, but somebody gets this information from the listserv, either Doe 1 or somebody who gives it to Doe 1. And Doe 1 happens to be the consultant that Curtis used, the employment lawyer consultant that Curtis used to get to formulate his strategies. And Doe 1 gives this information to Curtis. Curtis gives it to his client, and it's used in the attorney's fee hearing. Well, CIVA learns of this and says, wait a second, we have confidentiality provisions. We have provisions, a member who uses our listserv has to keep that information confidential. So somebody, whether it's Doe 1 or the person who gave Doe 1 the information, has violated our policies. And so they file a lawsuit. CIVA files a lawsuit against Doe 1 and other Does. But they need to know who is Doe 1. That's the starting point, right? And so they supposedly look into it and can't figure it out. So they try to get this information from Curtis. Well, Curtis obviously doesn't want to reveal this, and he doesn't want to reveal the identity of Doe 1. And so he objects, saying that's subject to the work product privilege, and he doesn't need to give this information. So the court looks at the code section 2018.030. It's not, the identity of Doe 1 is not something that's his impressions from the case, but the court says, well, maybe this is something, maybe Curtis can make a showing that this is something that would reveal his tactics or and would give the other side an undue advantage. And Curtis argues that giving the identity of Doe 1 might hinder him in the future from using either Doe 1 or other consultants who might be tempered by the idea, well, if their identity can be known, maybe I shouldn't work for a defendant in a case as a non-testifying expert. But in this case, because CIVA can't get the information any other way for their case, the court decides that the identity of the Doe 1 is not subject to the work product privilege, and decides that that information has to be given to, that Curtis has to disclose the information. And I thought this was interesting for 2 points. One is, the work product privilege side of it, but then also in thinking about this Doe 1 who got information from a listserv, whether it was that person directly or through another person, and then disclosed it in a consulting capacity. And, lawyers were aware of our duties to keep client information confidential, but it's important to think about what other contractual limitations you might have on disclosing information. All right.
Very good. So we're going to turn to another area that we will, Michael, I'm going to let Rachelle answer you that question while I move on. Former client conflicts of interest. And I think this is first of a couple of conflicts cases we're going to talk about, and something that you can easily miss. So we wanted to bring this to your attention. So here's the factual background of the case. In case number 1, the lawyer is representing a board, and in a deposition of a board member represents the board member who's not a party, but she is a witness, and so is acting as her attorney in connection with her deposition. She, in that depo, testifies that she did not provide confidential information from a closed board meeting, which was at issue in that particular case number 1. Fast forward to case number 2. Now, the same lawyer is going to take the deposition of the same witness. So he was representing her. Now he is taking her deposition. So he is adverse to her. And he's questioning her about providing confidential information and providing bylaws in the earlier case. So there is somewhat of a subject matter overlap here. And during the deposition, there are a lot of objections, as you can possibly imagine. And then there is a motion for disqualification that is based on Rule 1.9. That is the rule that governs former client conflicts of interest. And that is what the court has to evaluate. They say that, yes, the lawyer was representing Ms. Bartow in case number 1. So she was a client. And that's an important point so that you track it in your conflict system when you're representing someone in a depo, so that you then know that, you know, that person was actually your client. And then the court had to get into, are these cases substantially related? And the key word here was substantially, because the court ultimately concluded that disqualification was not required because the cases were not substantially related. There was only a slight overlap between case number 1 and case number 2. I think this is an important case because the court could have easily gone the other way. The courts have a lot of discretion in determining whether there is a substantial relationship. And so you do have to be super careful wherever there is a subject matter overlap between your prior representation and your current representation. Once you start asking questions that are delving into the subject matter of that first representation, then you are going to be at risk of disqualification. So to avoid that, of course, you want to try to get a conflict waiver if you can. But so that is the lesson from the Bartow case. No disqualification, but I think a close call.
Okay, and I'll just really quickly address Michael's question, and he asked the question about the Curtis case that, I'm going back to it. What are the elements for a qualified work product privilege? And it's the attorney first has to show that that allowing the opposing side to have this information would give it undue advantage of the attorney's efforts or impair the privacy needed for the attorney to learn about aspects of the case he's handling. So, but then it flips and the other side has to show that it would be prejudiced if it doesn't get this information. And so in this case, it was the fact that CIVILITY had tried, or at least the court said it had tried, and hadn't found out the identity of that Doe 1 otherwise. But it's unclear if you know, what level of trying it would have to do, or whether it could show prejudice in some other way. Okay. I'm going to talk about an ethics opinion. So the State Bar Ethics Committee came out with a few ethics opinions. We're going to talk about at least a couple of them today. And this one is about prospective clients and dealing with Rule 1.18. So a prospective client is someone who comes to you looking for legal advice, coming to see if you can help them out in your capacity as a lawyer. And you might consult with them, and then that might result in a representation or it might not. Well, even if it doesn't result in you being hired as a lawyer, if you get confidential information during that consultation, you can't represent the, you can't use that information or disclose it, first of all. And then whether you can be hired by the other side in that matter, if you have confidential information, you can't. But the rule allows your firm to be able to be hired if the lawyer who took the information only took reasonable measures to avoid exposure to more information than was reasonably necessary. And that lawyer is screened from the matter, timely screened from the matter, and written notice is given to the prospective client. The other way it can happen that the lawyer or the lawyer's firm can be hired is if the prospective client and the current client that will be represented give informed written consent. So this opinion talks about several scenarios. I'm not going to go into each of them because I think it will take too long. But I think it gives good guidance for lawyers to consider when they're interviewing or communicating with prospective clients. So in one of the scenarios, the lawyer meets with the client and doesn't say anything to the client about what this meeting is about. So doesn't say, you know, hey, we're getting together to see if I can help you. I need to run a conflicts check. So please give me the information I need to do that conflicts check. And then once that clears, we'll talk more about your matter or give me the information I need to see whether we can take on your case, what type of matter it is, who's involved, and then we'll go further from there. So it says nothing of that sort. And the client reveals confidential information. The lawyer asks open-ended questions, tell me about what's going on, that sort of thing. And the ethics opinion says that's not using reasonable measures to avoid exposure to information. So the lawyer wasn't giving any guidance about, you know, what to disclose or not, and got confidential information, and that didn't comply with the rules of taking reasonable measures. So on the other hand, there's another scenario where the lawyer takes information and the client, you know, says, don't only give me so much information as I need to do a conflict check, but the client starts blurting out more information. And in that case, the ethics opinion finds, well, the lawyer took reasonable measures. It so happens that the lawyer got confidential information, but the lawyer did take reasonable measures. So although that lawyer has the confidential information and can't serve representing a party on the other side of that matter, the firm could, the lawyer's firm could, assuming they comply with the rule otherwise. The other one that I want to mention is an example where they have a lawyer taking information from a client in parts. And so first, you know, give me the, you know, the names of the parties, what's this case about, so I can do a conflict check. And then later saying, okay, it came back clear. Now let's, you know, do you want to hire us? And the client saying, well, can you do this on contingency? And the firm saying, okay, now we need more information to decide if we can take this on a contingency. And so the lawyer is getting increasingly more information in order to evaluate whether the lawyer can take on the case. And in that case as well, the ethics opinion finds the lawyer was taking reasonable measures to take the information that was necessary to determine whether to represent that client, the prospective client. And so that complied with the rule as well, where the lawyer's firm could handle the other side if everything else was complied with in the rule. And finally, the ethics opinion discusses the idea of advanced consent from the prospective client to represent the other side. And the opinion suggests that that would work if there is informed written consent. And that would be required of the prospective client and then the client that they take on that's adverse. And so that's the facts are drawn up in that way in this opinion. So I think it provides, I would suggest reading this opinion because it has a lot of information in it, but those are sort of the highlights on dealing with prospective clients.
Okay, thank you. We have an interesting question. I think Sarah posted. Maybe Rachelle, you could chat with her about that. I'm going to turn to another conflicts question or conflicts case. This one is Klein versus Facebook. And we're in the middle of the great resignation, I guess, is what people are calling it right now. And so there's a lot of lateral movement from firm to firm by lawyers. And it struck me that this was an important case with that background that we're all going through right now. In this case, Facebook moved to disqualify the plaintiff's counsel who was handling an antitrust matter. And the basis for the disqualification was that a lateral lawyer had joined the plaintiff's firm after having represented Facebook in connection with an FTC investigation. And the both sides conceded and agreed that the matters were substantially related. So the FTC investigation was substantially related to the antitrust matter. They did not dispute that. So what the court had to look at was whether the lateral lawyer had substantially participated in the related matter, the FTC matter, when he was at his former firm. And he was a fourth-year associate, so mid-level, billed 800 hours in 6 months. He had a mid-level of responsibility with some contact with the client, but was not the lead attorney that was directly advising the client, and had exposure to information in his FTC work that was material to the antitrust matter. And they had put a screen in place to try to address this conflict of interest, but the screen was not timely. And accordingly, the firm was disqualified. The firm looked at these factors from Rule 1.10 in the Rules of Professional Conduct that get into how much the lateral participated when he was at his former firm, and found that it was substantial. And so therefore, even if the screen had been timely, most likely would not have resolved the conflict in this case and prevented the disqualification. But what happened was they had worked on that antitrust matter for a while without screening the lateral off. And so that was something the court also called into question. And so if you're going to be hiring a lot of laterals or any laterals, you're going to want to be very careful about looking into whether there was substantial participation, and then making sure that if you're confident there was not, that your screen is timely and you comply with all of the idiosyncrasies to be in full compliance with Rule 110. Otherwise, even if the participation was not substantial, you may still fail on the screen itself. So this is an important case as you're bringing in laterals to your firm, and I think sometimes very challenging to get to the bottom of it.
Yeah, and I think that's a really important point on the timeliness of the screen, because I think we think of a screen, but it's really important to get it right on the timing. Okay, so I want to just address Sarah's question really quick on the prospective client. And she brought up the issue of whether if a website of a law firm has, a page where somebody can put in information. And often you'll see with those that there are disclosures that, someone might need to saying, I'm not giving any confidential information or giving a warning of sorts. And I don't think the ethics opinion addresses this. I'm not sure now. But I would think that's similar to the warning in a consultation. You know, if a client says, you're not my client yet, we need to determine if we can take on this matter, and let's, you know, give me this information that I need for that purpose, and asking specific questions, that sort of serves the same purpose, that warning of, you know, don't give any confidential information. So if a prospective client then does give the confidential information, I would think that that would be seen as the lawyer taking reasonable measures. But I don't know if you have a different thought on that, Carole.
No, I think you've got to give the disclaimer and the warning that you're talking about, and but we don't know for sure what the true definition is going to be of reasonable measures. I think that is going to remain to be worked out in the case law.
Yep, good point. Good point that the ethics opinions are advisory. And speaking of ethics opinions, we're going to go to another one. This is by the San Diego County Bar Association. And it discusses firm or lawyer marketing. And I think this is something, you know, we all join groups. And so this is a good one to have in mind. So the facts of this opinion are somewhat narrow. And so, you know, it also says, don't read too much into this, but it involves a networking group where an attorney pays a fee to become part of this networking group. It's not just for lawyers, for all sorts of professionals. And in fact, there can only be one of each profession in a chapter of this group. So one lawyer, you know, maybe one accountant, one whatever. And they meet, and one of the purposes of this organization is for members to refer clients back and forth. And there's actually requirements of bringing people to meetings or how many referrals you make to continue being a member of this organization. But the organization's policies do say that if your profession has more onerous obligations on you, you don't have to comply with our policies. So if an attorney were to say, hey, I can't be required to refer, then the organization says, that's fine, you can still be a member and there's no requirement on you to refer. Well, this opinion looked at the Jackson case and looked at the lawyer referral statute in the Business and Professions Code section that's on the screen. And they said, well, you know, this organization is a lawyer referral service. We don't see it any other way. And even though it's not an organization dedicated to lawyers or that are only groups of lawyers, but it is operated in part, and that comes from the statute, in part of referring potential clients to attorneys. And so it's not a registered referral service, and therefore it's improper. And then the opinion also looked at Rule 7.2 in the Rules of Professional Conduct, at whether the lawyer was giving something of value in exchange for referrals. And it looked at the membership fee as something of value that it's giving money for referrals, even though the organization wasn't the one making the referrals, but it's the organization's policies and it's, you know, the way its policies are implemented that require referrals of the other professions. And so it treated that membership fee like compensation under 7.2. And then it also said that any referrals the lawyer did make, because presumably if the lawyer is part of this organization, the lawyer will make a referral, and that's a referral for referral, you know, that they're, because of the way the organization works, the lawyer would be getting referrals. So any referral by the lawyer is in exchange for referrals. And although there's exceptions in Rule 7.2 for referral arrangements, this wouldn't work because the organization is an improper lawyer referral service, and so it doesn't comply with the State Bar Act, and that's one of the requirements of the referral arrangement, that there's no violation of any rules or the State Bar Act. So like I said, the opinion does mention in here, we don't want you to think that any organization that you're a part of where referrals, it might be the reason that you join, to meet other professionals and so that you can develop business. But in this case, the facts are that it's an organization that requires referrals among its members. So that's the distinction that the opinion makes, or that's, that there's that quota system, and that puts pressure even on an attorney who's not required under the organization's policies to make referrals.
Yeah, I think that's a very interesting opinion and important for people to be aware of. Let's turn to a significant case on attorney's fees. This is the Carton versus RE Design and Construction. And in this case, I think there's a new arrow being put into the quiver of a judge who wants to cut your fees. And the new arrow is civility. And so I should also mention there's a bunch of pending changes to the rules that it will also potentially mention civility. But let's take a look at this case from last year. The homeowners in the case prevailed. They won a judgment against an unlicensed contractor who worked on the home. The court then was faced with addressing their request for fees. They requested $287,000 and some dollars. The court reduced it to $90,000. Quite dramatic. And we all know that courts do this. But in this case, the court used multiple reasons that we've all probably been very familiar with from before. They said that this was not a complicated case. The issues were not that complex. The case was over litigated. The result achieved did not justify the request for the fee that was being made by the prevailing party in the case. But then the new point, which the court brought up, is that one of the reasons for reducing the fees was the incivility that occurred in the course of the litigation. And the court said that the incivility that was involved in the case also increased the cost of litigation. And those of us who work in litigation, we know that that can happen. We know that that's, that happens if there is incivility in the case, as opposed to counsel getting along. That can really escalate the fees because you're just fighting about everything, even things that, reasonable lawyers would agree to. And so it's something to bear in mind. I have a feeling that this case will be cited in many upcoming requests for fees if somebody is trying to get those fees reduced, and they can point to incivility in the case as a factor that increased the costs. So because of that, we thought this case was important to bring to your attention.
Okay, and now we are moving on to continuing to speak about fees. I'm going to talk about the Misakian case and one other case that I'll give you the citation about in a moment, and I can put it in the chat as well. So the Misakian case involves an in-house counsel, and when Misakian was hired, he was discussing with his new employer his employment agreement to come on as an in-house lawyer, but it never got around to signing it with the employer. And so he comes on as the in-house lawyer. They're still sort of negotiating the agreement, or it turns out some terms in the agreement weren't quite right, and so they don't sign it, and it goes back and forth. But eventually, Misakian leaves. Now, the significance of this is that the agreement included a percentage fee. So he was going to get a base salary, but then he would also get a percentage that was based on litigation that the company had. And he would get it after the fact the litigation was ended. So the litigation ends, he's no longer in-house counsel, but he sues to get his fees. And the employer, Amusement, says, no, wait a second, we don't have a written fee agreement. So we don't owe this, the amount that the contract, the oral agreement says, because there's no fee agreement, and that violates Business and Professions Code 6147. Well, the trial court initially agreed, but then the case ends up going to jury trial, and Misakian was awarded over $2 million. So fairly significant, would be significant to me. And then the employer appeals and says, wait, we brought this up. This is a problem. There's no written fee agreement. And so the court has to decide, are wages for an employee fees under BNP Code 6147? And they ultimately decide that they are fees, and that because there were contingency fees, there was fees based on the outcome of a case, that there needed to be a written fee agreement under 6147. And the other case I want to mention briefly is Pesh v. Morgan. And again, I'll put the citation in the chat when I'm done. But that was another fee agreement case involving BNP Code 6148. There was no contingency fee. This is an hourly fee arrangement. And there were four matters that the lawyer was handling. Two had written agreements. Two, there were implied agreements based on a long understanding. And the court was deciding, the other side, the client who didn't want to pay, so in this case, the lawyer sued to get paid. And the client said, this rate is unreasonable that was in the written fee agreements. And they got an expert to say that this fee is unreasonable. Well, the court says we're not going to look at whether the fee is reasonable or not unless the fee is unconscionable. And so I think both of these agreements really highlight the need for lawyers to be sensitive to getting written fee agreements when they're needed, which is most of the time for most of us. But because these rules are very strict on how the fee agreement has to, what it has to include. And I think sometimes in the practice of law, we can move quickly and clients want things fast. And so, but it's important to make sure the fee agreement is in place.
Okay, we're going to turn now to another very important topic, ethical obligations of lawyers who are representing clients with diminished capacity. And this is from a state bar ethics opinion that came out in the past year. The number is 2021-207. Sorry, it's not on the slide, but it is a very good opinion because it covers a lot of ground. It's very long, but if you do have a client with diminished capacity, or maybe you do, I recommend that you go ahead and read it because it gives quite a lot of guidance as to how to handle the situation. And it covers all different sorts of practice. So it's not just in any particular type of practice. It really applies anytime you have a client with potentially who has diminished capacity. So what is the guidance? First of all, try to keep the attorney-client relationship as normal as possible. And so, of course, this depends on how diminished your client is. Clients may come in and out. They may have good days and bad days. They may have days when they're on medication and days when they're more cogent. Try to keep it as normal as possible is rule number one. Number two, take appropriate measures for communication. Think about what your client is saying back to you. Are they understanding things? Is it better to talk? Is it better to meet? Is it better to write? You still have your duty to communicate with the client, even if they are somewhat diminished in their ability to understand. Number three, preserve the client's decision-making authority. They are still the decision maker. You do not become the decision maker just because your client may have some diminished capacity. You still have to allow your client to be making decisions. Number four, make an informed and disinterested judgment regarding your client's capacity. This is a matter of competence, the opinion says. And so if you ever have been involved with dealing with a client who you think is potentially diminished, then you know how challenging this can be to do. The opinion, among the various guidance about how to deal with the situation, they suggest that you can consult with other professionals. You can potentially have your client be evaluated for their capacity with the client's consent. But it's something you cannot just ignore. You do want to tackle it and address it with your client. If your client consents, you can take protective measures to protect the client from harm. And this comes up in a lot of different scenarios, but one of them is elder abuse. And if you think that that is going on, then the question is, what can you do about it? Well, you still have your duty of confidentiality, and the attorney-client privilege also is still applicable. But those are subject to your client waiving or consenting to you disclosing information, as long as they have sufficient capacity to do that. And the opinion gives a interesting and I think a helpful explanation of what is capacity? What is it? And what is capacity to do this or that, to enter into a contract or to make other types of decisions, so that you will have that guidance. And then finally, something that I think is very novel and maybe a little bit controversial, the opinion says that you can consider getting an advanced consent from your client to make a disclosure that would be appropriate under the circumstances in the event your client is incapacitated. So you are representing someone, they're totally cogent at the time, but for whatever reason, you may think, all right, we would like to have a option in the future, to the extent the client becomes incapacitated, to make whatever disclosures are appropriate at that time. This advanced consent is something that you can consider, you can get from your client while they are still in possession of all their faculties and can give you that consent. Whether you want to do that, I think, is something to very carefully consider. The opinion gives you some guidance on how to go about doing it. And I think this is overall very helpful. You might not need it now, but if you run into a situation where you think you are dealing with someone with diminished capacity, it will be very, very helpful guidance and must read for you.
Yeah, I think this is also a reminder of how strict the confidentiality, the requirements on not using or disclosing confidential information of a client are.
I agree.
Okay, so Carole, I misspelled your name in the chat. I apologize.
Okay.
We talked about a client's diminished capacity. Now we're going to move to another ethics opinion just came out right before the one Carole just spoke about lawyer mental impairment. So this opinion, which again, all of these opinions are that we're talking about are fairly dense. And so if you have a question about any of these issues, I'd recommend going to look at the opinion because it has a lot of good information. But this one talks about, what should happen if a lawyer is mentally impaired and starts making some mistakes that are ethical concerns. So again, the starting point, like Carole mentioned with clients, is to assume or to not assume, mental impairment is not by itself an ethical violation. So it might be that a lawyer becomes impaired, but they can still perform their legal services competently just by adjusting a few things, maybe getting additional help in some ways, communicating in a different way. So it's not to say that the impairment itself is a violation, but in this opinion, the facts do include instances where the lawyer doesn't perform. Being confused or unable to represent the client at a hearing, and another lawyer, a subordinate lawyer, has to step in. The impaired lawyer gets a settlement offer and doesn't take it to the client. So there's a couple things going on that are now becoming ethical concerns. So the opinion goes into what a subordinate lawyer would need to do in that circumstance and what the supervising attorneys need to do. And this does depend on the situation. So whether there's a large firm involved or whether it's just the lawyer and a subordinate. And then the opinion does also address the personal interest conflict. So let me start with the personal interest conflict. The impaired lawyer, received a settlement offer and says, and when the subordinate comes and says, wait, we should have given that settlement offer, we need to disclose this to the client. The impaired lawyer says, no, we can't do that. That will hurt the reputation of the firm, will hurt my reputation, and we'll let the client know about this. No, we can't do that. So the impaired lawyer has a personal interest conflict, cares, it's his own reputation, the firm's reputation that he's concerned about. Now that doesn't necessarily, a personal interest conflict doesn't get imputed to the firm, but the opinion does remind us that it could be that the other lawyers within the firm would have a similar personal interest conflict and not be able to represent the client further. If, let's say, they all were concerned about the reputation of the firm and might be concerned about how this impaired lawyer's actions would be taken. But looking now at the subordinate lawyer's duties, the subordinate lawyer can't go along with unethical conduct just because they're a subordinate. So if there's something that's, an issue where there's, maybe it could go this way, maybe it could go that way, a subordinate lawyer is allowed to follow directions of a superior or their supervising lawyer. But if it's a clear case, and in this case, there are facts in the opinion where there are clear instances of ethical violations, then the subordinate lawyer can't just ignore those things. They have to do something. And that might be at a large firm going to the in-house ethics advisor. It might be reporting to managerial attorneys their concerns. But then they actually have to see that this is being followed through on. And for supervising lawyers, is putting into place the concept that's discussed in the opinion based on Rule 5.1 is putting into place measures for reporting to take place and guidance for attorneys to be able to report and up to management the impairment. And I'll stop there. This opinion is very long, and I suggest reading it further.
Yeah, especially if you're in this situation, you want to have really good guidance. I think that's very, very important. Okay, we wanted to touch on one state bar discipline case. And I thought this was an important thing for people to know. The state bar is now getting into the business of disciplining lawyers for conflicts of interest. I think for many years, the state bar did not really focus on this. And that's changed, is what I would say. So now if you have a disqualification, then the state bar may take a look at it and address and try to decide whether there is a basis for you to be disciplined in their discipline system. So in this case, the attorney involved, first of all, was defending client number one against a claim for fraud. Then in case number two, attorney starts representing client number two against client number one, alleging fraud, and also discloses some confidential information to the FBI concerning client number one. The court disqualified the attorney from representation of client number two based on a former client conflict of interest. And then the state bar gets into looking into whether there is a basis for discipline against the lawyer. And they find that there is a basis for discipline. The level of discipline in this case is not very high. The attorney had a public reproval, but the important point, I think, is for people to be aware that if you have a conflict of interest that hasn't been handled correctly, you are at risk not only of getting disqualified in the case, but also of state bar discipline. And so very important for people to be compliant with their handling of conflicts of interest. Somebody put, not very high is easy for you to say. Ask Ross Stein how high the level of discipline was. And that's a good point. And I'm sorry, I didn't mean to imply anything by that. I mean, the reason I'm bringing it to everyone's attention is that I do think it is important to know that the state bar can address this and that they are getting into this area. It's a risk, exactly. I think in order to get to a public reproval, there's a long way you have to go through the discipline process. Nobody really wants to go through that. And so complying with your conflicts of interest obligations and with the applicable ethics rules will avoid this type of discipline. Absolutely.
And there was a question about the mental impairment of a lawyer. And the question was, do you have a duty when opposing counsel appears mentally impaired? And I can imagine, there's no duty to your to their client. Certainly, don't have a duty to your adversary's client, but there might be a duty that could arise under a lawyer's duties of candor to the court, or general, duties of behaving in a way consistent under the State Bar Act. There's sort of the moral turpitude. I could imagine a scenario where it could come up where there's some duty to speak with the court on an issue, but beyond that, I'm not sure, Carole, if you have any other thoughts.
Well, the one thing I would say is we don't have a snitch rule in California. Some states you do have to snitch out other lawyers who commit ethical violations. And as Rachelle said to start with, being impaired alone is not an ethical violation. It's only when it affects your competence or your practice. But so you're not going to have an obligation to address this with the state bar. But one other thing I would say is I believe that you can make an anonymous contact with the lawyers assistance program to have them reach out to the person. I believe that is still available. I don't know whether I would do that without getting my client's consent. It may be something you want to address and discuss with your client before you decide to take any steps on it.
Good points. Okay, so there were this year a couple changes to the rules of professional conduct. Nothing major, but just thought we should point them out. The first is in Rule 1.1, dealing with competence. There was added a comment, and this is consistent with the ABA model rules, that competence includes the duty to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So as much as I want to put my head in the sand about technology and love using it when it works, we do have the obligation to know the benefits and risks of what we're using. It doesn't mean that we ourselves have to become technology experts. You might rely on others. You know, certainly many firms have IT help and or using sources to figure out what complies with our ethical obligations. But that is, and this is not seen as a change in law. In Rule 5.4, there was an additional provision added to allow fee sharing of settlement between a lawyer and a nonprofit that qualifies under 501c3. So a nonprofit, and there's some requirements as shown on this slide that apply to that situation.
And I think the technology point is a very good reminder. We're all using so much more technology than we ever used before, since we're working remotely and signing things remotely and communicating remotely. It is something that I think we've all become more and more aware of. And so I think it's good that they did add this into the rule. And I'm looking to see if we have any other questions. We have 1 minute left if anybody wants to post anything.
The proposal to Rule 5.4 is not to allow non-professionals to own law practices. That is something that is being considered, but no rule changes yet.
And I see, Kelly, your question, does this vary with professional expertise? I don't know which part of our presentation you're talking about, but if you're talking about the technology, it does make it harder to practice out of your wheelhouse. If you are not familiar, you're talking about patent law and family law, just those two areas have a lot of very specific technology that relates to those practices. So I agree with you. Learning all of that, it does make it any more of a challenge to go back and forth between different areas. I do not know the answer to where can you go to look at it later, but I'm sure somebody can post that for you. Well, I think we are wrapping it up. We're just about out of time, and we really appreciate everybody attending today. And I know this went by very fast. So feel free to reach out to me or to Rachelle if you do have questions about anything. We tried to touch upon a lot of things in a short period of time. So let us know if you have any other questions. And it's great being able to be with you guys today.
Yes, ditto everything that Carole said. Thank you.
Okay.